Yeah.
Okay. Hi, everybody. Thank you for coming today. My name is Adrienne Yeung. I'm the Senior Intellectual Property Officer here at UC Merced. And this webinar session is about intellectual property and its commercialization. So what is intellectual property? Well, we're going to start with this brief video that tells you what intellectual property is. Okay, it's not working. Little technical difficulty here. Should be a video. It's not coming up. Should we start the recording over? Oh, you're live. Oh, okay.
I don't think we've ever done a video before.
Okay, no worries. Okay, so we can't watch this video, which is fine. No worries. So what is intellectual property? Well, intellectual property is a property right where the government grants ownership to certain intangible creations of the human intellect. And what does that mean? Well, it means that it's a grant by individual governments. So one government is going to be different from another. So what's allowed in, Africa is going to be different than what's allowed in India, and it's different than what's granted in here in the US. So it's different, it varies by country. But what is the same is that you can sell, lease, inherit, assign it, you can do whatever you would like because it's considered your own property. So intellectual property started with our founding fathers. They designed the patent system so it would stimulate the inventive genius and entrepreneurial energy of the common man. And they added it to their Constitution. So in the Constitution, it's added to Article 1, Section 8, Clause 8, which allows Congress to, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings and discoveries. Well, what does all this mean? Well, it means that an owner can exclude others from using their intellectual property for a limited time. So they have a small, limited monopoly right to prevent others from using their inventions by providing a financial incentive during that time. So there's 4 types of intellectual property. There's patents, trademarks, copyright, and trade secrets. So we're going to start off with patents first. So what is a patent? Well, a patent is basically a contract between the US government and an inventor. It gives the government gives the inventor the right to exclude others from making, selling, using, offering for sale, or importing within the US. But at the same time, what does the government get? Well, the government gets the right, the government needs the inventor to disclose the invention to the public, which then encourages innovation, right? The more knowledge in society, the higher technology there will be. And in this time frame, the inventor can monopolize, find a short monopoly on for their invention and make some money off of it. So how do you get a patent? Well, in order to get a patent, there has to be three things need to be fulfilled. First is it has to have some utility. It has to be useful. It has to perform some type of function and be operable. Then the second is it has to be novel. It has to be new, and it has to be something that's never seen before. The last thing is it has to be unobvious. So people skilled in the art, it has to be not obvious to them. So there's a couple of different types of patents that we have here. There's the utility patent, a design patent, a plant patent. And within the utility patent area, there's what's called a provisional and a non-provisional patent, which I like to just call a regular patent. So let's start with what utility patents are. Utility patents can protect nearly everything made by man, which is including software and genetically engineered animal and bacteria. Utility patents involve things that are functional. For example, like a new drug, a wafer cleaning process, solar systems, and even a new type of beach blanket, which I actually previously patented. It was a beach blanket on the corners. There were pockets on the corners and to put sand in there so the beach blanket wouldn't blow away. So under the utility, recall I said there were two types of utility patents. One was a provisional and one was a regular non-provisional patent. Provisional patents are not examined by the PTO and does not become a patent. It's basically a placeholder to say, hey, everybody, I invented the invention on this day. You can mark your products as patent pending so that people know that you have a patent pending on it. And it expires 1 day from the date of filing it. Before that 1 year comes up, you need to file what is called the non-provisional patent or the regular patent. This is the patent that's examined by the PTO within a few years. And on this one, you can sue if you're granted that patent. You can also mark your products patent pending. However, this non-provisional patent expires 20 years from the date of filing the non-provisional. And there are maintenance fees that are due after it's granted. So you have to pay those maintenance fees as well. The second type of patent is a design patent. Design patents protect the non-functional look of something. So for example, when mouses first came out for computers, there's a ton of design patents for mouses. So it is, in essence, it prevents competitors from copying the appearance of your product. It's the ornamental features that are considered here. Design patents expire 14 years from the date the patent was granted, and no provisionals are allowed for design patent applications. The third type of patent is a plant patent. And these are like the least numerous types of patents because it takes forever to get these. It grants protection on asexually reproduced new variety of plants, i.e. the use of grass. It expires 20 years from the date of filing, and no provisional patents are allowed for plant patents. So now we're going to move on to what trademarks and service marks are. So a trademark is a word, phrase, symbol, and/or design that distinguishes your goods or services from another party's goods or services. So it just basically, it identifies you as the company. So trademark is the name for goods, and service mark is what's used if you provide services. But the essential purpose of a trademark is to protect against counterfeiting or misrepresentation by competitors. So trademarks attach, common law attaches to trademarks, which means you actually own this trademark once you start using it. Trademarks, but the thing is, if you register a trademark, it creates the legal presumption that you own it. And you can also sue in court if an infringer or if somebody else uses your trademark. So it's basically your ticket to court. Trademarks don't have an expiration date as long as you continue to pay the renewal fees and as long as you use it and it doesn't become generic. So what are the requirements to get a trademark? Well, trademarks cannot be similar to a pre-existing trademark because, well, it creates a likelihood of confusion, right? It'll confuse your company with another company, so it can't be similar. It also cannot be generic or descriptive. So if your company is fixing phones, your phone cannot be, your name of the company cannot be phone fixing company. The best type of trademark to get is what is called fanciful or arbitrary marks, meaning it requires some thought to determine who the source or who the company is or what the product is. And some examples are Clorox and Exxon. So if you looked at Exxon, you wouldn't know, had no idea what it means, and nor would you know that it belongs to a gas company. Same with Clorox. Clorox, what is Clorox? Doesn't mean anything really. So these marks are fanciful and arbitrary. It requires some thought to really think about who the manufacturer is or what the product is. So there's 4 types of trademarks that you can get. You can get it on logos, you can get it on sounds such as the NBC News sound, you can get it on color, and you can get a trademark on smell even. So we're going to move on to copyrights. So copyright protects the expression of an idea. It does not protect the facts or ideas themselves. So different copyrights, or what you can get a copyright for, are books, like sculptures, films, even software you can get a copyright for. Sound recordings and a musical work can be copyrighted. What's not copyrightable are recipes, characters, titles, and slogans, which are actually covered under trademarks. So copyrights allow the holder to exclusively reproduce, provide derivative works, distribute copies, publicly perform, and display their work. So what are derivative works? Well, derivative works are works based upon the pre-existing work, right? So it can be a translation, it could be a musical arrangement of a movie, it could be a motion picture version. It's just, something it's an improvement on their pre-existing work. So the copyright must be in a tangible form, meaning it has to be capable of being copied, and it has to be an original work. The term of a copyright is the author plus 70 years or 95 years if it's a corporate owner. There is one exception to copyright usage, which is for fair use. And generally it's for teaching or non-commercial uses, research. Those are not considered infringement of a copyright. But fair use could be a whole nother topic. So there was a movie for this one, but since we can't watch movies, we'll just talk about it really briefly. So then we're going to move on to trade secrets. Trade secrets means information that derives economic value from being, if it was generally known. So it's something like a formula or a pattern or a program, things that can earn a company money, but it's also kept a secret or is maintained as confidential. So what kind of information can be considered a trade secret is pretty broad. It can be formulas, like I said, recipes, your distribution plan, things that may not work, like negative information, or innovations that have not been disclosed. So how do companies protect your trade secrets? Well, one thing is they make the documents marked as privileged and confidential. The second way is by using non-disclosure agreements, which are agreements that each party agree to maintain as confidential. And the third way is by not disclosing it, not publishing it, right? And that's the way you keep things a secret. So now that we learned about all these different types of intellectual property, how is it actually all used? Well, many companies use a blend of all of them, right? They protect their name through a trademark, protect software through a copyright, protect their products through patents. And most companies also keep a lot of information confidential, and so they use trade secrets laws as well. In using all these types of intellectual property, a company can use them offensively or defensively. If they use their intellectual property offensively, they just protect the things that they're making at the time. However, many companies actually use a defensive stance, and they actually file patents for inventions that they think their competitors will also make. That way they can, keep that tight knit and make sure that there's no other company will come in and sell a similar product that they are selling. So here at our tech transfer office, the purpose is to assure that relevant UC research is developed into products and services that can benefit the public. Because publishing alone is not always enough. So remember that UC Merced has 3 pillars of research, teaching, and public service. So it's great to publish and teach, but publishing and teaching doesn't always translate to benefiting the public. So we here at the Tech Transfer Office are here to assist anybody that needs to protect their intellectual property rights so that you can make those products and put it out into the public. So where do you first start? Well, the first thing to do is to first disclose your invention to the Tech Transfer Office. And in that, you need to submit an invention disclosure as soon as possible. So US here changed their laws, and it's now that the first to file will be considered the inventor. Thus, someone may file before you, and you'll no longer have any patent rights. So first is to disclose, and then the second is to publish. So once you disclose, the second step is to form a company to sell the products and services directly to the customers. And the third is to license your technology to other companies. And licensing is actually, we have a lunch and learn next Monday at noon, where we will have an attorney from Nixon Peabody to talk to us about licensing options. So I hope you guys can join us for that. So are there any questions?
We do. So we have about 6-7 people online.
Okay.
So one question is, what happens when a copyright expires? Do you have to go through the process completely over again?
So once a copyright expires, it actually goes into the public. There's no renewals for copyrights.
And then I just have a question. So let's say there's students that do have their own businesses, like a lash business or a nail business that they do just as a side hustle as students. But let's say they have a new shape for nails, or they do something different to lashes. I know a lot of people are putting like little gemstones on the lashes. So let's say it's a little something different from what others are doing. Is that possible to kind of go into one of these avenues?
That's a good question. So like a different nail design could possibly be a design patent. I don't see any other way you can really protect it other than that. Maybe, it's a good question. I don't see any other way, actually. Yeah, maybe is there a different way of putting it on, perhaps? If there's a different process of that you're using to put things on or to take things off, that could be patented. That's a good question.
Yeah. Go into the chat. What is the difference between copyright and trademark?
Okay, good. That's a good question. So if we can go back. So trademarks here are basically, it's your name, a company's name, or a slogan, or it could also be, let's see, what else do we have here? Oh. It could be a sound, the color of your company, the smell, just the name or logos that they have. Whereas a copyright is actually more like books or software or sculptures, paintings, things like that.
I didn't know smell. I thought that was interesting.
Yeah, that's actually recent, actually. Yeah, I've never done one for smell, but that's a recent one, yeah. So apparently Play-Doh trademarked their smell.
So how did it work before, when you like those like markers that you write with, and then they would smell like strawberry or grape?
Very good question. I have absolutely no idea.
How they did that?
Yeah. Since it's pretty recent, I actually didn't know either until recently too.
That's cool. Do you happen to know how much it costs to register a copyright?
Ooh, I haven't done that one in a while, actually. It's pretty inexpensive. I'd say it's less than $100. Yeah, it's probably even less, like less than 50 probably, but it's been a while.
And to use the tech transfer office, do you have to be a part of UC Merced? Is it limited to a certain audience, or can anyone come in?
That's a good question. I want to say it's limited to faculty and students here at UC Merced.
But students can, undergraduate,
Correct.
PhD.
Yep.
Will my personal information be available to the public if you register a copyright?
That's a good question. I don't know the answer to that. I'd have to look that up and get back with you. That's a good question. I don't know.
And if any of our guests would like additional questions, is there a way to public or like look you up for an email or anything to send you any questions if they are UC Merced affiliates?
Yeah. So my information is up on our website at the OTIIR website, I believe, or just ayeung11@ucmerced.edu.
That is a roundup of our questions. So I don't know if I should say thank you from over here, or, or if you just want to do a quick wrap up before
Yes,
we...
I can do a quick wrap up. So knowing that there's 4 types of different IPs, patents, trademarks, copyrights, and trade secrets, just know that you can use all of those to make a successful company, but you will be using a blend of all of them for a company. So if you have any questions, feel free to reach out. More than happy to chat anytime. Thank you everybody for coming.